Thank you. This hearing is in regards to case number CFI 024-2020 before Her Excellency Justice Maha Mheiri. The claimant is represented by Al-Tamimi and Company. Lead counsel is Mr. Matthew Watson. The defendant is represented by Afridi and Angel. Lead counsel is Mr. Sulekshana Sinanayaki.
Good morning, Your Excellency. I appear for the applicants, that's Sunset and Patura. And as Your Excellencies probably gather from the papers, this is the hearing of an application to commit the respondent, Miss Herz, for contempt of court. The specific contempt is breach of an order of Justice Roger Giles made on the 27th of May 2022 following a trial. The issue for Your Excellency is actually quite straightforward. It relates to two Dubai companies called Black Tap Restaurant and Coffee LLC and Brick Oven Restaurant LLC. I'm just going to call them Black Tap and Brick Oven. And after a trial in this court, Justice Giles found that Miss Herz was not entitled to any shares in those companies, and he ordered Miss Herz to transfer her shares in those two companies to my clients. She has not done that. In fact, she's done precisely the opposite of that. She secretly went to the Dubai Economic Department and procured the transfer of my client's shares to herself, so that the position today is that she has 100% of the shares in these companies registered in her name. That's the very opposite of the position that Justice Giles wanted to bring about. And that, in a nutshell, is why Miss Herz is in contempt of court. And at this hearing, I'm going to be inviting you to make a finding of contempt, to make a committal order referring the matter to the Attorney General of Dubai, to impose a fine, and to make orders requiring Miss Herz to undo the share transfers that she procured. There are some other ancillary orders as well, and I'm going to deal with those at the end of my submissions. But before I embark on my submissions and take Your Excellency through it, there's a procedural issue to deal with first. I note that Ms. Herz is present at this hearing. I can see that she's joined the Microsoft Teams call. I just need to check about whether Ms. Herz is intending to give oral evidence at this hearing. If she is, then that should happen first, and I can cross-examine her, and then we'll each make our submissions.
Your Excellency, I can confirm that Ms.
I can't hear my learned friend.
Apologies, Your Excellency. I can confirm that my client, Ms. Herz, has joined the meeting and is ready to give evidence if required. However, speaking of procedural issues, I wonder if Your Honor has seen our email to the registry yesterday, where less than 24 hours ago, the applicants have sought to amend their application without the permission of the court. In that regard, I'd just like to draw Your Honor's attention to section 81.28 of the White Book, where it specifically explains that any amendment to a contempt application has to be with the permission of the court. I'd just like to place this on record that we've had less than 24 hours to deal with the amendment, or have not been given notice of it adequately. So that is a serious procedural issue. And I invite Your Honor to consider how that should be dealt with at some point in this hearing as well. Thank you.
Just so that Your Excellency has my position on my learned friend submission. My submission is quite straightforward. I'm not amending my application. Just because the precise wording of a draft order changes to make it slightly more accurate does not mean that an application is amended. I make precisely the contempts that are set out in the application notice that was issued and served at the start of these proceedings. I don't invite Your Excellency to make any finding of contempt that's not in that application notice. All of the orders that I seek, a finding of contempt, a committal order, a fine, and orders requiring Miss Herz to undo the share transfers that she procured, they were all set out in the very first skeleton argument that my clients served several weeks ago. So I do not accept that there is any amendment. I don't need to amend, and this hearing should simply proceed. In relation to Miss Herz giving oral evidence, it's not for me to say about whether she needs to. It's about whether she wishes to do so, and she needs to indicate that now. If she does, then I will cross-examine her. And we'll deal with her oral evidence. If she doesn't, then I'll simply proceed to make my submissions.
Your Honor, my client has already submitted an affidavit, her evidence in the form of an affidavit to the court. So if my learned friend wishes to cross-examine her on anything that's in that affidavit, he's free to. But other than that, she has, unless Your Honor wishes to speak to her or ask any questions, or the court wishes to, she won't be volunteering any further evidence. Everything has been set out in affidavit form.
Let's hear Ms. Hana Herz's submissions. Mr. Matthew, if you want to ask any questions, please, you may do so.
Well, I think it sounds like I mean, there are aspects in her affidavit that I disagree with. So it sounds like we're going to need to cross-examine her, which means that she's going to need to come on, be sworn in, and confirm that her affidavit is correct, and then I shall cross-examine her, and then I'll make my submissions afterwards. That in my submission is the appropriate way to proceed.
Yes, Ms. Hana Herz, please.
Your Honor, yes, I agree with my learned friend that should be the way to proceed. I could start by asking Ms. Hana whether she has set out her evidence in the affidavit dated 26th of September 2022, and whether she confirms the content of that affidavit.
I think she needs to be sworn first.
Shahla, can you go through the procedure, please?
Yes, Your Excellency. Miss Hana, would you please state your full name and occupation for the record?
So I cannot hear. There is echo. Sorry.
Mr. Salakshana, can you please mute your microphone? Okay, can you hear me now?
Yes, I can.
Thank you. Please state your name and occupation for the record.
Hana Herz.
Thank you.
Thank you.
Sorry, I interrupted you. I apologize. Please state your full name and occupation for the record.
Hana Herz, self-employed.
Will you be swearing or affirming today?
Swearing.
Do you have the Holy Book in front of you?
Yes, I do.
Please put it in front of the camera so we can see it.
Yeah, here we go.
Thank you. Thank you. Please place your right hand on it, on the Holy Book, and repeat after me.
Yes, I will.
I swear by the Almighty God.
I swear by Almighty God.
To tell the truth.
To tell the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you.
Thank you.
May I proceed, Your Excellency?
Yes.
Ms. Herz, you have given an affidavit on the 26th of September 2022. Do you confirm the contents of that affidavit?
The witness statements you're talking about?
The affidavit of 26th of September. I'll just show this to the camera. And,
does Miss Herz have a copy of the bundle?
She has a copy of her affidavit. She doesn't have the entire bundle. I think we should send her a link. Yes. It might be easier if we put out any document that we'd like her to see on the screen rather than her going through the bundle.
If it assists, Your Excellency, I can probably share my screen.
Sorry, if I may just ask a question. Is it the one Sunset Hospitality? Excuse me? Okay.
Yeah, you will see that now on the screen.
Yes.
So, if my learned friend could scroll down to the signature page. Yes, do you confirm that you affirm this affidavit? Is this your signature?
Yes, it is.
And you confirm the contents of this affidavit?
Yes.
Yeah, that's all from me.
I'm grateful to my learned friend. Miss Herz, I'm going to ask you some questions about Black Tap and Brick Oven.
Yes.
They are both Dubai companies. Black Tap was set up in June 2016, wasn't it?
I don't know the perfect dates when it is set up, but I know it is set up somewhere. We had the talks in 2014 and the setup was followed.
If I just show you, if I delete these, can you see here paragraph 41 of the judgment of Roger Giles, where he says Black Tap was incorporated in Dubai on 26th of June 2016.
Yes.
And you see it had 200 shares, share capital of 200,000 dirham divided into 200 shares. Do you see that?
Yeah, which is 51% shareholding. Yeah.
Yeah, and 102 shares were registered in your name, weren't they?
Yes.
And 98 shares were registered in the name of Sunset Hospitality Holdings Limited, weren't they?
Yeah.
And Brick Oven was incorporated in July 2016, wasn't it?
Yes.
And it also had 200 shares.
Same arrangement. Yes.
Yeah, so 102 shares in your name and 98 shares in Pitura FZ LLC.
Yes.
And you signed a nominee agreement in relation to each company, didn't you?
I did after that, but this is only for the purpose that they assured me it is for the business purposes and to attract more businesses and shareholders and move on. If I didn't have that one, I would never sign a nominee agreement.
On the 22nd of February 2020, my clients asked you to transfer your shares in Black Tap and Brick Oven to them, didn't they?
Yes, they asked me.
And you didn't transfer your shares to them, did you?
I did actually. I did transfer 51% to them.
Now, I'm talking about in February 2020, it's before the trial.
Before the trial? Oh, no, I didn't.
You didn't, and that was why there was a trial, wasn't there? It was one of the reasons for the trial.
I suppose so. Or I believe so.
And my client's case at that trial was that the nominee agreements meant that they were the real economic owners. Do you recall that?
No, I don't recall that. That is to their belief. My belief is this nominee was only for the purpose to increase business, and because it is not even endorsed or authorized by Dubai court, which my company is a Dubai court, and I have the MOA that is clear. This is the reason why I believed, and the lawyer also assured me this is not going to be used ever. You have all the emails there.
But let's look at what Justice Giles said in his judgment. Can you see on the screen paragraph 55 here?
Yes.
The nominee agreements are clear. Mrs. Herz paid nothing for the shares. She is the registered legal owner in order to comply with the requirement of 51% national ownership, but they are beneficially owned by Sunset or Pitura, and Mrs. Herz will transfer them at the request of the Sunset company. Unless the nominee agreements are for some reason ineffective, they establish the position as between Mrs. Al-Herz and the Sunset companies, whatever it may have been in their absence. Do you see that?
Yes, and I know the judgment very well.
Yes. So my client's case was that they were the beneficial owners of these shares, and you were contending that the nominee agreements were for some reason ineffective.
You were talking backdated. If they became effective after going to through the trial, and the judge has ordered something, he thinks that the nominee is clear, and I think he did order that I should transfer 51% to them.
Yes. So let's just look at one of the things that you said. So do you see here paragraph 84 of the judgment?
Just can you please lower it for me? Thank you. 84, you said?
84, it's there. Can you see?
I'm sorry, can you just scroll downwards, or I don't. Yeah, thank you. No. I can't see it, I'm sorry. Yes, okay.
Do you see 84?
Yeah.
Mrs. Al-Hertz's evidence included, however, that she had paid for her shareholdings. There was no such evidence in her first witness statement dated 20th of April, and it came in a further witness statement dated 22nd of July. She claimed to have paid for her shareholdings, reflects that simply acting as the required 51% shareholder did not, and certainly did not in her mind, mean that she was the beneficial owner. And you see at 85, Miss Al-Hertz said that she paid 450,000 dirham towards my share capital. Do you see that?
Yeah, 400,000, yeah, to his wife.
So one of your arguments at trial was that you had paid for the shares, wasn't it?
But is this the, sorry, I am confused. Can I, Your Honor, is this we're going back to for the first case, or we're talking about my respect to the judgment of transferring the shares?
I'm asking you questions about the judgment at the moment.
This is already, we went through that case earlier. I'm just asking Your Honor, are we going backwards to the same first case, or we're doing the case that is we're talking about respecting the judge order?
Mr. Matthew, your line of question is going to which direction?
It's going to Miss Al-Hertz's understanding of what she was required to do by Justice Giles, and also in part, as will become apparent, her credibility.
I'm sorry, I don't, I understand, Your Honor, I'm sorry to interrupt, but I don't see any relevant of what, sorry, your name, Matthew, is talking about, because my understanding, I read proper English, if you may, it's not my language, but I do understand. When I read the judgment, I did exactly, with respect, what was asked from me to do.
Miss Al-Hertz, this process will go a lot simpler. Miss Al-Hertz, this process will go a lot simpler if you simply answer my questions.
I'm sorry. I will not answer anything related to the old case. Unless this is something you want to combine both cases, Her Honor has to tell me what to do, because I don't see any relevant going backwards answering the same thing. I've been through this with them already, and the judgment came out. Now, please, to my understanding, that I will be only talking about respecting, and because of your harsh, let's put it this way, that you're saying that I should be in prison because of I didn't respect the judge order.
Miss Al-Hertz, this is not an opportunity for you to give a speech. You are to answer my questions. My first question was, you have one of your arguments before the trial was that you had paid for the shares that are the subject matter of this dispute. And I just want to show you what His Honor Justice Giles said about that. Can you see in this part of the judgment, he said, I am unable to see Mrs. Al-Hertz's evidence in relation to the payment of the 450,000 dirham as anything other than a concoction in a misguided attempt to bolster her position that she was the legal and beneficial owner of her 51% shareholdings in Black Tap and Brick Oven. Do you see that, Miss Herz?
Yeah, I saw that, and I know that that is what Sir Roger saw or believed in, but I'm sure that I have my evidence before. I don't want to go backwards and talk that it was...
So, Miss Justice Giles, when he says concoction, he means that you made up your evidence, doesn't he?
Why would I make up evidence if I have everything black and white? I have a copy of the check. He received it in his wife's account, and why would I do this?
So you're saying that Justice Giles was wrong in his judgment?
I'm not saying it is wrong. I'm saying, you know, now
Sorry, can my learner friend turn his mute on? Justice Giles upheld the nominee agreements, didn't he?
Are you talking to me? Sorry.
Yes, Miss Herz.
Oh. Upheld means?
He found that the nominee agreements were valid, didn't he?
Clearly it says yes.
And he found that the 51% shares that were registered in your name, in fact, belonged to my clients, didn't they?
According to his judgment, he said yes, transfer the 51 because he ignored the MOA, which is the real contract that is endorsed, and only stood with the nominee agreement.
Sounds like you disagree with his judgment, Miss Herz.
It's not about disagreeing. I'm a human being. I can feel.
Sorry to step in, Mr. Watson, and Your Honor, I do apologize, but I believe my client has a right to be advised that or at least that she should answer your questions. And when you do put in a question, if you could please put it in parts, because as you know, my client's first language is not English. And Ms. Herz, you also have the right to remain silent if you do not wish to answer a certain question. Thank you.
Thank you very much.
Are you aware, Miss Herz, of Justice Giles's order? I just want to bring it up on the screen. Can you see it?
Yes, I can see it.
He required you to transfer your 102 shares in Black Tap and Brick Oven to my clients, didn't he?
Yes, which I did.
You were required to do that within 14 days, weren't you?
Yes.
That was, do you see this order is dated the 27th of May 2022? You see that?
I can see it.
So 14 days was the 10th of June 2022, wasn't it?
Yes.
And you didn't transfer your shares by the 10th of June 2022, did you?
That's because both Al-Tamimi and my lawyers were talking, and I wanted to see the draft, which is my right to review.
You wanted to see a draft.
They have already put in the portal for the transfer, and then I wanted to see the draft. And also with respect to your client, they had some wrong names in the draft, that they wanted to transfer the shares to another company, which doesn't match with the judgment.
Let's have a look at the draft, shall we?
Yes.
So this was the first draft. This was sent to you on the 6th of July. Can you see it?
Yes.
So one person limited liability company, Black Tap Restaurant and Coffee LLC. Do you see that?
Yes.
Contract was drawn up on Tuesday, corresponding to 5th of July 2022. Do you see that?
Yes.
And that's your name, Hana, Habib, Mansoor, Habib. That's you.
Yes.
And Sunset Hospitality Holdings Limited. That's the first applicant, isn't it?
Yeah, the Dubai one. The order says rack.
So that was your error. That's what you say was an error.
That's not only the error. They also sent me something saying I have received all my rights and I don't, lot of stuff sent to me. And that's why my lawyer and their lawyer were having negotiating. And, you know, I have to wait till my lawyer and me, I'm satisfied about what I'm signing.
So you have to wait until you're satisfied. That's your position, is it?
No, and also just to add to your point, I felt sick. And then when I tested on the 19th, I had COVID and I couldn't go out. And then also my child had it, and then my husband. This was the reasons why I didn't go. And when I went myself to DED, because they want to enforce that I should only visit one staff who's sitting in Buhel, which is right away from where I live. And if I should go to DAD to transfer, I can go any branch and transfer.
You haven't produced a PCR test with your affidavit, have you?
No, I gave my lawyer my PCR, of course.
Well, your lawyer hasn't given it to us.
I'm sorry then. I've forwarded my certificate to them to know. But anyway, this is something, I'm not lying. I can show you if you want.
Well, I'm going to suggest to you that that's another concoction, Miss Herz.
Mr. Matthew, let's stick to what's going currently and not talk about the past.
Yes,
Ms. Herz, now we can see that the shares are still under your name, and that's against the order of Justice Roger Giles. Your submission in relation to that matter would be helpful in this situation.
okay. Your Honor, I want to transfer the 51% and do as per the judgment. When I went to DAD and showed them and told them this, I have to transfer this, blah, blah, they said, leave it with us because one, Black Tab main was expired for more than 6 months and we cannot do any transaction unless this is renewed. Then they said, give me the MOA and I have to submit all the papers to them. After 2 weeks, I think, or this, they came back to me, they said, we have passed this to our divisions, related divisions. They said that I have a right as per Dubai courts to transfer all the shares 100%, and then you can do the transfer of the 51 to obey the judgment of the IFC court. This is exactly what happened, Your Honor.
But you did not do the transfer.
I did.
Now you transferred all the share under the companies?
No, I transferred the 51 to them, and I sent them endorsed from the notary and from Dubai court.
Yeah, but the order was not that you transfer 51%. It's 100% of the shares go under the company.
But the order doesn't say, Your Honor, I have to transfer 100% because they saw it. Everybody, this is not me, Your Honor. It is gone through the proper channel with DED and the notary and who represent Dubai court. And their view in the judgment is 51, which also Al-Tamimi confirmed it is 51. They took the right from the nominee, Your Honor, and I have the right under my MOA.
Miss Herz, you did before you took my client's shares, you did not contact my clients to tell them what you were doing, did you?
It is not my job to contact them. It is DAD or the notary's job to contact them because they do it in the system. They only called me to sign, by the way.
So you had four, but you didn't have to sign, did you?
If I have your
If the
client,
D,
and you don't want me to take my right?
if the DED said to you, "Oh, you can have 48% of these shares," you should have come to my client and said, "We need to sort this out at the DED, not just take 49% of my client's shares."
So when your client also took my whole right of 51, I never asked anything. I obeyed the court order. I didn't even appeal. I just want to move on.
Why aren't you offering to transfer 100% of the shares in these companies? You're not entitled to any shares in the companies, are you, Miss Herz?
Why am I not entitled? I am a partner, 51%. All documents.
No, that is exactly what that's exactly what Justice Giles found you were not. He found that you had to transfer your 51 to my client.
Your Honor, Sir Roger only saw the nominee agreement. And the court ignored the MOA. So through the nominee agreement, he saw that, and then when I'm now like I'm lost between Dubai courts and the IFC courts. I'm respecting all courts, by the way. I haven't done something illegal. Everything went legal. If they said this is my rights and they put it in the system and it's endorsed.
Miss Herz, do you recognize this document that's on the screen? The Memorandum of Association for Brick Oven, the MOA.
Yeah, I can remember it by heart, but I can see that, yes.
You can see it, can you?
Mm-hmm.
And do you see Article 21 of, it's on the screen, headed miscellaneous? Do you see that?
Yes.
And there's Article 21(4). Do you see that?
Yes.
This was the article that you relied on before the DED, wasn't it?
I didn't rely on anything. I went to transfer the 51. They relied on whatever legal matters they have. They did it, not
Okay.
you. I haven't asked for it.
Do you see this document, Miss Herz?
What?
You see,
What?
this is a deed of share sale and amendment of MOA for Brick Oven. Do you see that? It's page 190, Your Honour, Your Excellency.
Okay.
Can you see that?
Yes.
And do you see the first party is Petura FZ LLC? Do you see that?
Yes.
And this deed says represented by you in accordance with separate provisions contained in Article 21.
Mm.
So this is a deed that says that my client, Petura, is represented by you in accordance with Article 21. Do you see that?
This is the one I have submitted?
This is what you signed before the notary public on the 9th of August. Do you see the
submitted?
Yeah, this is what you used to transfer.
I didn't use this for anything, Matthew. This is all legally done. It was given legally to me. It was notarized. Otherwise, are you saying I'm corrupted with the government sector and with the AD and notary?
I'm putting to you, this is the deed that
Yes.
you relied on to transfer the shares in Brick Oven. You see, it's got limited liability established by virtue of commercial license under the trade name Brick Oven.
Yes.
Memorandum of Association. As the second party, that's you, wishes to sell all the shares of the first party, that's Petura, my client, to herself in accordance with the separate provisions contained in Article 21. That's the Article 21 that I've just shown you. amending the distribution of profits, and then it's 100% of the shares, all of the shares get registered in your name. Do you see that?
I can see that.
Did you read this when you signed it?
It's a standard form, by the way, with Dubai courts. Maybe you have to tell someone in Dubai from here.
Did you read it before you signed it?
Well, I only saw that they told me there that you will own 100% and you have the right. And then
Did you read it before you signed it?
I didn't sign the whole. Nobody reads all the pages, all these pages. All I've seen is that I will own 100%, and they told me I had a right.
Well, I suggest to you that that's not what happened. I suggest that you deliberately went and signed this document, and I'll show you your signature. There's your signature. You signed for both the first party procurer and that's my client and yourself. You deliberately went and you deliberately signed a document registering 100% of the shares in this company in your name.
You can say what you think. That's
well,
not
I'm putting to you that is what you did.
More of my holy Quran, by the way, to say the truth, and I'm saying the truth. And it is, if they tell me to sign, and I have to sign. It's not deliberately or all what you're saying, because I will not accept also when you said I secretly went. I don't go secretly. Why would I go secretly?
You didn't tell us that you were going to the Al-Barsha branch of the Notary Public and the DED, did you?
I can go any branch I want. First, I didn't go to Barsha. I went to Wafi. Then the closest to my house to go and sign was Barsha.
But you didn't tell us that you were going before you went, did you?
I think my lawyer would have spoken to Al-Tamimi and said, I don't need to go to their recommendation and to the lady, or I don't know which staff they gave me the name in Abu Hail. Because
you didn't
here, so you don't know the distance we're talking about.
You didn't tell my clients that you were going to transfer their shares to yourself before you did it, did you?
That I didn't tell him, and it's between lawyers. I didn't.
Well, your lawyers didn't tell my clients that you were about to transfer their shares to yourself, did they?
Then maybe DAD had noticed them, because if they do anything, it goes to the notice of the client automatically.
But that would happen afterwards, wouldn't it?
No, it would happen when you apply for the application, not after we finish.
No, I suggest to you that you went and you did this without telling anybody, certainly without telling us.
You can say what you want. That's not my intentions and will never be my intentions. I've never in my whole life done anything secretly or have been going around the bush. Alhamdulillah.
And you sent a share transfer document, didn't you, to my clients? Do you see this in the Arabic?
The lawyer, yes, he sent it to them.
Yes, your lawyer sent this, and I think this is a translation of, at least in relation to the brick oven. Do you see that? The share sale agreement?
Can see that now, yes.
Yes. And so what you are proposing is a share transfer where you, because you are at the moment registered with 200 shares, you're proposing to give my clients 102 shares, aren't you?
I'm not proposing. I am just respecting the judge. There's an order to transfer 51% from Black Tab and Brick Oven, in which I'm doing it.
Right, but
because there's nobody, if they own 100%, will go willingly giving somebody else.
But so you accept, don't you, that what you want to do is to keep the 49% that you've obtained?
In the case that I can see here and legally under the MOA, I can see I have the right to keep the 49%.
Well, let's look at that, shall we? This is the Memorandum of Association for Brick Oven. Do you see that?
Yes.
And you relied on Article 21. And did you see that here?
Let me, excuse me, I need to make you understand. It's not me who relied. You keep on pointing fingers on me. You think I am a notary or a lawyer. I'm not. I'm a human being, simple human being, businesswoman that went to DAD to transfer the 51. They told me I have rights, and they went through the legal, and the notary was there and everything. They saw all documents, and they said, under this, it is them. So should you have a question about this legally, please, Matthew, refer to DED or notary, because I can't answer you in this regard.
You said a moment ago that you had a legal right to take my client's shares. Are you now saying that actually you don't know whether you have a legal right? You're just going on what the DED told you.
No, excuse me. I didn't say I didn't know. When I went there, I didn't read the memorandum, by the way. They attracted my attention that I have the right. That's what I'm saying. Let me repeat it again.
Well, I suggest to you that that is wrong. I put to you that the DED would not tell you, just apropos of nothing, that you were entitled to take my client's shares. I suggest that what really happened was that you went there with that deed and you asserted that you were entitled to my client's shares, and you signed a deed for my client and you signed a deed on behalf of yourself, and the DED simply registered it. That's what happened.
So you mean I have enforcement on government sector like DED and notary?
I don't know how you did it, Miss Herz, but the result of what you did was that you took my client's shares.
There is no magic. This is legal document, and if you don't approve the legal document, then please feel free to go and tell Dubai court what you feel. I don't have enforcement. Unless you are saying I have enforcement, I am corrupted with them. This is not me. The endorsement doesn't belong to me.
Your Excellency, I think I've put everything that I need to put. I don't have any more questions for Miss Herz. I think I can, and unless my learned friend's got anything by way of re-examination, I think I can move on to my submissions.
Your Honor, may I say something, please?
Yes.
Your Honor, please, I need to clear one thing. I swear to God, and I swore on the Quran, I went to the intention of transferring the 51%. I was not in a good health. I have a baby that have no nanny. I have a mother that is in bed that I take care of her from morning till evening, which they don't know, and I don't need to share this. I know it's not their problem. And when I was okay, I went for this intention. The DAD and notary told me I have the right. Legally, they said, and this is all legal, Your Honor. It is stamped by Dubai courts, and he's telling me I was secretly, deliberately. That's all I have, Your Honor. I have respected.
Okay, thank you.
Thank you, Your Honor.
Your Honor, may I ask a few questions in re-examination?
Yes, please.
Ms. Herz, you have seen the judgment of Sir Roger Giles, haven't you?
It's not right. I remember the judgment.
Yes. What was paragraph? I'll read paragraph 1 of the judgment, which says, within 14 days of the date of these orders, Mrs. Herz transferred to Sunset Rack the 102 shares held by her in Black Tap Restaurant and Coffee LLC. And paragraph 2 is similar, except to say that you shall transfer 102 shares held by you in Brick Oven Restaurant LLC to the Sunset Parties. When you read those two paragraphs, what did you understand?
It was too fast what you said, but
sorry, can I just put it this way? When you read the first two paragraphs of the judgment of Sir Roger Giles, was it your understanding that you were supposed to transfer 102 shares of the two companies?
Yes.
Right,
Which
and yes. Go on.
there is echo.
Can you hear me now?
Yes, thank you.
Yes, so it was your you confirmed that it was your understanding that you had to transfer 102 shares of the two companies, correct?
Yes, which is 51%.
Yes, and you didn't, can you hear me? Apologies, let me just fix this for 1 second. Can you hear me back?
Yes, please.
Hello? Yes. When, so that was your understanding of Sir Roger Giles' order, correct?
Correct.
You said you were ill with COVID. Do you remember the time period where you had to stay in quarantine?
I think 19 June.
Did the sunset parties, did you think that you were obliged to tell the sunset parties when you were visiting the notary public?
No, because there is nowhere it says that I should.
What, did you select a certain notary when you visited the notary public, the branch that you selected, was it out of convenience or for any other reason?
I didn't select. As a matter of fact, I visited 3 departments. One, Wafi. Anywhere that I drive and it's convenient for me, I used to stop and complete the formalities. It is all there. And I visited Jumeirah, the DAD cafe, and then for signing, because I live in Al Manara, Barsha was closest to me, so I had to go there.
So it was for convenience.
Yes. So it's not
yes.
I went to 3 places.
Did you, are you able to influence anyone in the Dubai government or the notary public to transfer shares in a manner that you want?
I don't think anybody is.
Are you aware of any person who has ever transferred shares without, or rather, let me rephrase that question. When you did transfer the shares or when you were advised to transfer the shares, did you do that because you wanted to comply with the judgment?
Sorry,
Hello?
I didn't.
When you transferred when you were told to act in the manner that you did by the DED and the notary public, was it your intention, or did you follow that advice to better comply with the judgment of Sir Giles in the way that you understood it?
Yes. And
So
I will
you had
sorry,
go on. Sorry, go on.
I said I will always comply because all my life I've been complying with everything and respecting everything I do.
And are you ready to transfer 100% of your shares if a clear order to that effect is issued by the court?
Honestly, I will leave it to the court of DIFC to see the fairness in this, because if they rely on a nominee and I rely on a MOA, I legally, all legally has been done. I cannot enforce any court to say anything. I can't talk on behalf of DIFC, but I hope that they see fairness in this and I take my right.
And it is your intention, sorry, finish.
No, nothing else.
And you never had an intention to disobey an order of the court or disrespect the court, is that correct?
All my life, all my record, I'm not a young lady, I'm in my 40s. I've never in my whole life have the intention or will ever do this in my whole life. I will always respect.
Thank you, Ms. Herz. That's all from me. Thank you.
I think Ms. Herz can be released, Your Excellency.
Thank you. Mr. Matthew, your submissions.
Thank you, Your Excellency. I was going to take my submissions.
Sorry, do I need to leave or stay?
It's up to you. But your part is done for in this session. Now it's Mr. Matthew's turn.
Okay, thank you. Thank you.
Thank you.
Yes. Your Excellency, I was going to take my submissions in 4 parts. I was going to just address briefly the law on contempt, and then the facts, and then thirdly explain why Miss Herz is in contempt, and then fourthly I was going to make my submissions on the sentence and the orders that Your Excellency should impose. Just in relation to the law of contempt, in the DIFC, I think this is common ground. The law reflects that in common law jurisdictions like England, there are 3 important principles that Your Excellency needs to bear in mind when dealing with contempt applications, and they're to do with, firstly, the standard of proof, secondly, the burden of proof, and thirdly, the mens rea, or the mental state that I need to prove. I can deal with this in relation to one authority, but if Your Excellency is familiar with these principles, I can just set it out by way of submission. But if Your Excellency would like to see it in the case law, I can take you to it. The leading decision in the DIFC courts is Justice Wayne Martin's decision it's called Latif and Lamia. You'll find it at page 521 in the bundle. It was handed down in March of this year, so it's pretty much the latest word on contempt. But the 3 core principles are this, and I don't expect that these would be disputed. Firstly, when you're dealing with the standard of proof, the standard of proof is different. It's not the civil standard, which is the balance of probabilities. It's what's called in England the criminal standard. So you have to be sure of a fact beyond reasonable doubt. It's not beyond any doubt, but beyond a reasonable doubt. And in England, what judges say to juries is, are you sure that something happened? That's the standard to which you need to be satisfied when you're dealing with questions of fact. The second key principle is in relation to the burden of proof, and that is essentially that the burden is on me as the party seeking to establish the contempt. So I have to satisfy you of the facts to the relevant standard. The third point, and this is perhaps the most important one, is the mens rea, the mental element, because there is some subtlety to this test. In short, contempt is sometimes referred to as a strict liability offence because it doesn't turn on whether the individual intended to breach the order. What matters is whether the relevant individual intended to do the act that amounts to a contempt. So they don't have to intend to breach the order, they just have to intend to do the act. So they can believe that they are not breaching the order. They can believe that they are complying with the order. They can even be advised that they are complying with the order. But if that's all wrong, if in fact what they do amounts to a contempt, then they are in contempt. And that's a very important principle in this case, because Your Excellency will see from Miss Herz's affidavit, and you heard it in her evidence now, that she insists all the way that she was simply doing what she was advised. She believed that she was complying with the order. That's what her evidence is. Now, I suggested to her, and it's my case, that that's not true. I think in my submission, she knew precisely what she was doing, which was to try and give herself leverage so as to effectively denude Justice Giles's order of any purpose, because he'd ordered her to transfer 51%. So in order to defeat that order, she just grabbed my client's 49%, so that when she offers 51%, that's effectively a hollow offer because she's still keeping the 49 that she has taken. But even if Your Excellency were to believe her when she says I was intending to comply, that doesn't save her, because whether or not she subjectively intends to comply is not the test. What matters is whether she intended to do the act which amounts to a contempt. And here in my submission, the acts are: 1, not transferring, and it's plain that she intentionally has so far not transferred because she's not actually physically done what she needs to do the transfer. And secondly, she intentionally did the relevant acts before the DED. So she signed the deed. No one forced her to sign that document. She did it intentionally. She didn't accidentally sign it. She did it intentionally. So she did the act. She may have believed wrongly that she was entitled to do so, but that doesn't save her from a contempt. So that's the civil standard. I just want to deal against that background of the law. I just want to deal with the facts. I set them out in my skeleton argument at paragraph 7. In my submission, you can find all of these facts to the criminal standard, so you can be sure of them, because they're either not disputed or they derive from the judgment of Justice Giles. And you heard that Miss Herz disagrees with certain findings, evidently, in Justice Giles's judgment. And I showed you, for instance, that Justice Giles wasn't satisfied with the evidence that she had given. His conclusion, having heard her give evidence, was that parts of her evidence were a concoction, and she challenged the basis on which he reached his conclusions. But those conclusions stand because they are the conclusions in an authoritative judgment of this court following a trial. Well, the starting point, none of this is disputed, is that you've got 2 Dubai companies. 98 of the shares were in my client's name and 102 shares were in Miss Herz's name. She was registered as a nominee, but as Justice Giles found, those shares were only registered in her name to satisfy the old law about 51% Emirati ownership of companies. In reality, they belonged to my client. They were the beneficial owners of those shares, and I showed you the positions, the paragraphs of the judgment in evidence with Miss Herz. But I'll perhaps just show you, if I might, Your Excellency, page 48 of the bundle. Paragraph 104. That is Justice Giles's conclusion. The nominee agreements stand. Sunset and Patura are the beneficial owners of the respective shareholdings, and Miss Herz is obliged to transfer the shareholdings to them. And you can see at paragraph 105, he refers back to the request that my clients had made back in February 2020 for the transfer of these shares. She had refused. That was the purpose for the trial. And that final sentence, there's no reason to decline to give effect to the beneficial ownership of the Sunset companies. Sunset Rack and Patura are entitled to orders that Mrs. Herz transfer the black tap and brick oven shares to them. So this is the situation following the trial, is that these companies are our companies. They're our companies completely because we owned 49% and Miss Herz owned 51%, but she owned them purely nominally. They were beneficially ours. So the starting point, as Justice Giles found it, is that we are the proper owners of 100% of the shares. Now, all that he needed to do, this is Justice Giles, was order her to transfer her 51%, because at that time, those are the only shares that she had registered in her name. And he ordered her to transfer the shares in 14 days. And the purpose of that, the purpose of the order, was to bring about a situation where my clients were the only registered shareholder of these companies, because they're the only ones who are entitled to these shares. As you've seen, Miss Herz had to comply by the 10th of June 2022. She didn't do that. It's been suggested that she had COVID. Whatever the reason is, she didn't do it. My client provided copies of the share transfer forms on the 6th of July 2022, and I showed Miss Herz a copy of that document in oral evidence. Maybe I'll just take you back to it, Your Excellency. You can take it from page 74 in the bundle.
Okay.
And these are, as Your Excellency can see, they're standard form DED documents, and they provide for my clients already being the registered shareholder of 49%. They provide for the transfer of the outstanding 51% of the shares, and Miss Herz says, "Oh well, this one refers to a Sunset Hospitality Holdings in Dubai, not Ras Al Khaimah." But if her problem was minor and technical, what would have happened is her lawyers would have gone back and said, "Can we just adjust the draft to say Sunset Hospital Holdings Limited, RAC?" And then my solicitors would have made that change and sent the document back to her. That's how these things normally go. So that all she would have to do is to enter her signature at the end of the document. It's on page 81, before the public notary, to effect the transfer. And this was provided to her in July 2022. And had she simply done that, that's what a party who's complying with the order, that's what would have happened. The 51% of the shares would have been transferred, and I wouldn't be here troubling Your Excellency. But she didn't do that. She didn't do that. What she did is she went to the Dubai Economic Department, where she signed 2 deeds of share sales and amendment that had the effect of transferring all of my client's shares to her. So she produced a result that was completely the opposite to the one that Justice Giles was intending to bring about. So he was intending to transfer all the registered shares into my client's name, and she went and did the opposite. Now, I just want to show you the deed. Let's take Brick Oven. It's at page 190.
Okay.
It's pretty obvious from reading this deed what was going on. It says, in the preamble, that the second party wishes to sell all the shares of the first party to herself in accordance with the separate provisions contained in Article 21. And over the page on 191, it makes it pretty clear that what is going to happen is the transfer of all of the shares to herself, so that she will be the registered shareholder. Now, let's assume, for the sake of argument, that Miss Herz is telling the truth when she says she went to the DED and presumably she walked in and she said, "I'd like to transfer my 51% of the shares to Petura." And the DED just turned round and said, "Oh, no, you don't need to do that. You're actually entitled to all of the shares. That's what you're entitled to under Article 21 of the MOA." Now, as I suggested to her, that is just an incredible story. That's not how the DED operate. But let's assume that that's right. If she was genuinely trying to comply with Justice Giles's order, what she would have done was she would have stopped what she was doing. She'd say, "OK, I need to go and talk about that with the other party." That's what an honest party would do. She would have gone to her lawyers, and we would have got an email from her lawyers saying the DED have said that actually there needs to be a transfer of all the shares to my client. And we could have sorted it out in front of the DED. But she didn't do that. She just signed the deed. She signed one in relation to Black Tap, and then she signed one in relation to Brick Oven. And she didn't even tell us that she was doing it. So we found out later. when her lawyers sent through a document, which I'm going to take you to shortly. But she didn't even tell us, and it's the underhanded nature of the way in which she went about it that is the basis on which Your Excellency can find that something wrong has happened, because a party who attended that trial and who fairly accepted the judgment of Justice Giles, which is that my clients own all the shares, if that was her position, she wouldn't have gone in and just signed these deeds. She would have come and spoken to my clients, but she didn't. And I'll make clear why I say that she didn't. But she was relying on, in this document, you can see that what's relied on, you can see under sale and transfer on page 191, in accordance with the separate provisions contained in Article 21. That's the MOA. And Miss Herz, her evidence shifted quite a lot. At times she was like, I've got a legal right to these, I've got a legal right to these. But whenever that was challenged, it was always, oh, well, I don't know, I'm not a lawyer. I just relied on what the DED tell me. And that inconsistency in my submission is quite revealing of what was going on. But I'd just like to show you Article 21. It's at page 820, Your Excellency.
Okay.
You'll see Article 21 is there set out. Now, little subparagraphs 1, 2, and 3 don't really have anything to do with the shares at all. They're all fairly miscellaneous provisions. And then you can see little subparagraph 4, which says, in case of non-local partner leave out of UAE for more than 6 months, or non-renewal of the said company trade license for more than 2 months, they, that is the non-local partner, authorise the UAE national partner or his representative to access his shares, including his shares selling to himself or others, or to make any changes in license, including company name, activity, and withdrawal of partners or dissolve, etc., etc. The critical parts of this are the opening few words. In case of non-local partner leave out of the UAE for more than 6 months. Well, my client is a Ras Al Khaimah company, so it can't be out of the UAE, so that doesn't apply. And then it said, or non-renewal of the said company trade licenses for more than 2 months. So what needs to happen is the trade license needs to expire, and then it needs to not be renewed for 2 months. And that wasn't the case. And if Your Excellency looks at page 772,
Okay.
this is, sorry, actually, I think it's 773. That's my error of a reference. 773.
Okay.
You'll see a payment voucher. This is the payment voucher that Miss Herz produced. And for when she paid for the transactions that she carried out. And you can see the trade name Brick Oven Restaurant LLC. And you can see that there was a license renewal, and you'll see the expiry date, 18th of September 2022. That's on the left-hand side. And then expiry after renewal, 18th of September 2023. Does Your Excellency see that?
Yes.
So the original license wasn't due to expire until the 18th of September 2022. So she'd gone to the DED on the 9th of August. So that's almost a month before the license had expired. And Article 21 only applies if the license has expired and 2 months have passed. So it wouldn't apply until the 18th of November 2018. So she asserts that she has got a legal entitlement to rely on Article 21, but in my submission, she does not. And that gives the lie to precisely what is happening here. I'll just show you the other article that she relied on. It's the equivalent article in for Black Tap. It starts at page 784.
Okay.
This is the Memorandum of Association for Black Tap. And if you scroll down to page 806,
Okay.
you can see Article 19. And it says, if the trade license of the company is not renewed for a period of 6 months following its expiration, and I accept that that was the case, then what this clause says is the second party authorises the first party, who is the local partner, to amend the Memorandum of Association and convert the legal form of the company and the contract with self, assign exit and sale of shares owned by the second party, and contact the Economic Department and all the relevant authorities in the UAE in this regard, sign documents, applications, permits and undertaking necessary for this purpose, and to act on behalf of the second party and in the capacity of manager or in the name of the company, and this is the crucial part, Your Excellency, in order to enable the first party to close any bank account opened by the company and to amend the Memorandum of Association to enable the first party to carry out any actions that may reasonably be required to effect the liquidation or winding up of the company. So it's actually quite a narrow clause. The purpose is to allow the liquidation of the company. So it's not envisaged that if Article 19 is relied upon, anything happens but the termination and liquidation of the company. And Ms. Al-Herz doesn't say that she's doing any of that. And the second point is it's premised on Ms. Al-Herz being the local partner. But by this point, Justice Giles has already held that she is a nominee only and obliged to transfer her shares. So as a matter of substance, at the time that she went before the Dubai Economic Department, she was under an obligation imposed by this court to transfer her shares. So the true owners of those shares are my client. That's the true position. She wasn't allowed to do anything else with them. What Article 19 envisages is a situation where you've got a genuine local partner who's entitled to their shares, and the non-local partner just abandons the company. So they don't do anything in relation to it. And the purpose of Article 19 is to say, well, if you're not doing anything with the company and you've let the trade license expire, then I can come in and just close the company down, because I'm the local partner and I don't want to have any liabilities or responsibilities in relation to this company anymore. But that's not the situation that was here. In fact, the situation is completely the opposite. Not only had my clients not abandoned the company, but they've been trying for 2 years to get hold of it. They'd asked Miss Al-Herz to transfer her shares in February 2020, but she refused, and we had to go to a trial in this court in order to try and get control of it. So in my submission, neither Article 19 nor Article 21 entitled her to do what she did. Now, Your Excellency's heard reference to the various branches, and I just want to show Your Excellency some of the email correspondence. If Your Excellency could go to page 101 in the bundle.
Okay.
And you'll see towards the bottom of that page an email from my instructing solicitors Al Tamimi, Mr. Brooks, to her Miss Al-Herz's former lawyers. Dear sirs, thank you for your email. We note your client's intention to now complete the transfers. By this point, we were completely unaware that our shares had been taken. As requested, please find attached trade license and MOA documents for Sunset Rack. Please note the documents are not needed. And then there's this paragraph. Your client should visit DED Al Nessa branch. If your client then attends counter 6, a lady called Hint will assist her. And we even give a Google Maps reference to the branch. So my clients had made it as easy as possible for Ms. Herz to comply with this order, because we'd gone to a particular branch of the DED. We'd even spoken to somebody. We'd left the documents there and just told her, you just need to turn up to the counter and sign the documents. But she doesn't. She goes to another branch of the DED. And in my submission, it's revealing why she went to a different branch, and that's because she well understood that the staff at the Al Nessa branch knew what was going on. So what she did, and if Your Excellency scrolls up to page 100, you get the email on the 16th of August from her former lawyers, Abdul Hakim bin Herz. I think that's her brother, who is at the time acting for her as her lawyer. And you get a very strongly worded email saying that our client has already signed all necessary documents and paid the notary fees on both transactions, and the shares of 51% being officially transferred in the name of 2 entities in compliance with the above order, and 2 documents are attached in Arabic. So this is the first time we find out that she's gone to the Al Barsha branch, not the branch that we've been dealing with, but a totally different branch. And at least on its face, it looks like she's going to comply, because they're saying she signed a share transfer form to transfer 51% of the shares. But my instructing solicitors had to get the Arabic translated, and the translation of the documents that she was putting forwards, you can see one of them at page 151.
Okay.
This was the document that we in fact found. This is the Black Tap one. There's an identical one in relation to Black Oven. Was that what she was proposing was a sale of the company shares, a transfer of 102 shares, but where she, and you can see this at the bottom under amendment of the article regarding the company share capital, but where she, the first party, retains 98 shares. This is the first time that we realized that actually what she'd done was procure a series of transactions that allowed her to appear as though she was giving away 102 shares, but somehow she's left with 98 shares. So she starts out on the 27th of May, when Justice Giles makes his order, with 102 shares, and she's proposing to end up now retaining 98 shares. So this is the transaction that she wants my client to endorse, and it's pretty obvious why she wants my client to sign this document, because she wants a document signed and notarized before the Dubai Economic Department, where we are somehow endorsing this situation where she's left with 98 shares. And that is just not going to happen. And so there are 2 important points for Your Excellency to bear in mind. The first is that Miss Herz said in her affidavit, and she said in her evidence, that she was doing all of this to enable efficient compliance with the judgment. But if that was true, why has Miss Herz not offered to transfer all the shares back to my client? This document should say second party 200 shares. There's nothing in the judgment that allows Miss Herz to retain any shares in the company. What Justice Giles envisaged was that my clients would have the entire shareholding in these companies, and there's no basis for her to acquire any shares. So if she was just being helpful, she would have offered to transfer all the shares back to us, and she hasn't done that. And the second point, as I say, is that she did all of this without informing us. It was only on the 16th of August that we actually discovered the true position. And that's not the conduct of a party seeking to be helpful and compliant. That's the conduct of a party seeking to frustrate an order of this court. And the final fact, Your Excellency, of which you can be sure of, is this, that as things stand today, Miss Herz is the registered shareholder of 100% of the shares in these two companies. So my clients have no shares registered in their name, completely the opposite to the position that Justice Giles envisaged. So those are the facts. I just want to briefly address my submissions about why Miss Herz is in contempt. And in my submission, her contempt is established in two ways. She's been ordered to transfer shares in Black Tap and Brick Oven to my client. She's not done so, so she is in breach of the order. That is plain and simple. She says she's offered to transfer 102 shares, and I've shown you the offer. And so her case is that she's offered to comply and done everything that she needs to do so. But that is against the backdrop of Miss Herz having taken my client's shares in these companies. So while she's offering to give with one hand, she is taken with the other and is trying to engineer a situation where in practice she keeps some shares. And that's not what Justice Giles intended. And there are two reasons why her offer to transfer 102 shares doesn't constitute compliance. And the first reason is that Justice Giles ordered Miss Herz to transfer her original 102 shares in each of these companies. But she's taken 98 shares and now offers to return 102. But the question for this court is this: is Miss Herz offering to transfer the same 102 shares that Justice Giles ordered her to transfer? Because another way of looking at her offer is that all she is offering to do is to return the original 98 shares that belong to my clients plus 4 of her original shares. And that wouldn't be compliance at all, because that would still leave her with 98 of the shares that Justice Giles ordered her to transfer. Now, she says that she's offering her original shares, but why should Miss Herz be allowed to dictate which shares she is offering? Courts don't allow a party to dictate themselves whether they are in compliance with an order or what compliance requires. That is always a matter for the court. And Justice Giles intended that after Miss Herz complied with the order, my clients would have all 200 shares. So by making her offer in the way that she has, she's trying to say that she complies, even though that leaves her with 98 shares. And there's nothing that requires the court to see things in that way. Your Excellency is entitled to look at this offer and say that is not an offer that complies with what Justice Giles required you to do, and therefore you are not offering to comply, and therefore because you haven't complied, you are in contempt. The second way of looking at it is this. By going to the Dubai Economic Department and taking the shares that belong to my client, instead of just transferring her 102 shares, she's frustrated the purpose of Justice Giles's order. And I set out in my skeleton some references to the authorities, and it's perhaps easiest just to take them from my skeleton, if Your Excellency has it. It starts at page 827 in the bundle.
Okay.
And paragraph 13 and 14, I set out some paragraphs from a book called G on Commercial Injunctions, which is the leading English textbook on injunctions in a commercial context. And you can see, and I'll read it for you, Your Excellency, a mandatory order, and Justice Giles's order was a mandatory order because it required Miss Herz to do something. A mandatory order necessarily includes a prohibition forbidding the defendant from doing anything or permitting anything to occur which would disable him from complying with the mandatory terms of the order. So as a result, a party who, with notice of the order, disables himself from complying will be liable to be proceeded against for contempt of court. And the learned editors of that textbook explain that that's because once a defendant knows of the order, is prohibited implicitly by its terms from doing anything which would prevent him from complying with it. If he does anything which would prevent him, he is in contempt and can be proceeded against by committal or sequestration. So the principle is that if you're ordered to do something, you've got to do it, and there is an implicit prohibition on you doing something else that prevents you from effectively complying. The classic case of this is where someone is ordered to produce documents, and instead of actually producing the documents, they just go and burn them or destroy them, and thereby disable themselves from complying with the mandatory order to produce documents. But it's not limited to that situation. It's a principle of genuine application. So what one has to do is to look at the purpose of the order and ask whether the defendant has done something to disable herself from being able to achieve or fulfill the purpose that the court was trying to bring about. And in my submission, that's exactly what Miss Herz has done. She's disabled herself from complying because she's brought about a situation where literal compliance with the order doesn't achieve the court's purpose, because she's evaded its real effect, the order's real effect, by seizing our shares and then only offering to transfer some shares back. And I gave a simple example of this to illustrate it for your Excellency in my skeleton, about how a party could behave like Ms. Herz and just completely frustrate an order. If you imagine that the defendant had taken 50 dirhams from my bank account, and the court orders the defendant to repay the 50 dirhams. And what the defendant does is just takes another 50 dirhams, so that the defendant's now got 100 dirhams, and then offers to pay the 50 dirhams back. And the defendant says, aha, well, I've complied because I'm offering to transfer 50 dirhams back, and that's all that I was ordered to do. But that's not real compliance, because what the court has done, what the defendant has done, is something to render the literal compliance totally nugatory. What the defendant's done is to find a way of defeating the purpose of the order. And now you might say, well, okay, well, you make another order to transfer another, to repay that 50 dirham. But if the defendant just takes another 50 dirham, you could get a constant circle where nothing ever changes. And in reality, that defendant always has 50 dirham in their hands. And that's precisely what Miss Herz is doing here. She was ordered to divest herself of shares so that at the end of the day, she wouldn't have any shares. But what she's done is to take some shares and then say with one hand, oh, well, I'm prepared to give you some shares so that I look like I'm complying with the order. But in reality, she's keeping 98 shares so that in substance, and the court has got to look to the substance, not the form, in substance, what she is doing is undermining completely the purpose of the order. That, in my submission, is a contempt. She's impeding this court from achieving the ends that it wished to achieve. And so in my submission, however the court looks at it, Ms. Herz is in contempt. So if Your Excellency finds that she is in contempt, Your Excellency, you need to consider the appropriate orders to make. And I'll just make some brief submissions on that. The principles were set out by Justice Martin in Latif and Leela, and Your Excellency will find them at page 548 of the bundle. I don't propose to take Your Excellency there now, but you may wish to just read that the passage that starts at page 548, where Justice Martin sets out the sentencing principles. There are two types of order that Your Excellency can make by way of punishment. The first is to refer the matter to the Attorney General of Dubai, and the second is to impose a fine. These are not exclusive, so you can do both, or you can do one or the other. In my submission, you should do both, and that's because there's been a breach of a court order. This is a serious matter. The order required compliance within 14 days. so by the 14th of June 2022, and it is now the 4th of October 2022. There has not been compliance, and there has not even been an offer to comply. There's been no apology for the conduct. Ms. Al-Herz's approach shows contempt for this court's orders in the true meaning of that word. Rather than do the very simple thing that was necessary in order to comply, she's embarked on a course of conduct that frustrated this court's order. It's put my client to considerable further expense. It's meant that this court has had to sit for 2 further hearings after trial. All of that, in my submission, makes this serious enough a contempt to warrant a referral to the Attorney General of Dubai. And I also say that you should indicate to the Attorney General that this is the sort of case that should attract imprisonment. You obviously, Your Excellency, can't bind the Attorney General or the Dubai courts who consider the criminal conduct. So you can't control how those courts and the attorney deal with this matter. But this court can express a view, and in my submission, it should. In my submission, you should also impose a fine, because this is serious conduct, and it's not clear what the Attorney General will do or how long that process will take. And this court ought to mark its immediate disapproval of Ms. Al-Herz's conduct. And the only order it can make in that regard is a fine. And you'll see from my skeleton argument, if Your Excellency has it at page 829 of the bundle. Sorry, actually, it's 830, the next page over. I've referred to some English and some DIFC authority. The English authority is Absolute Living and DS7 Limited. The DIFC authority is Gulf Wings and AK Trading. In both of those cases, there was a breach of an order. In Gulf Wings, it was failure to stop an asset from leaving the jurisdiction. In Absolute Living Development, it was the failure to provide the information about assets that's required under a freezing order. And in both cases, a fine of 100,000 of the relevant currency was imposed. So in England, it was £100,000, and in Gulf Wings in the DIFC, the fine was $100,000. Now, in those cases, there was no additional reference to the Attorney General in the DIFC, and there was no sentence of imprisonment in Absolute Living. So I don't say that you should impose a fine of that level, because that's a fine that was imposed where that was the only punishment. And if you're going to refer her to the Attorney General, which I submit you should do, then in my submission, a lower fine is more appropriate to reflect the fact that there are 2 punishments that are being imposed, an immediate fine and a referral. And that's why in my submission, the appropriate fine is one of $75,000. And just to be clear, for Your Excellency, a fine is a sum that Ms. Al-Herz must pay to the court. So it doesn't go to my clients. It's paid as punishment to the court for disobeying a court order. I'd just like to take Your Excellency through the draft order that I prepared, so that Your Excellency can just understand the precise relief that I'm seeking. You should find it at page 832 in the bundle.
Okay.
So the recitals set out the contempts that I'm inviting you to find, and then at 833 you get the orders. 1 to 3 are the sentences that I'm inviting you to impose, namely referral to the Attorney General and payment of a fine. Paragraph 2 provides that the fine gets paid to a bank account nominated by the registry. I understand that's how fines work. The registry gives an account at which the fine can be paid into. And paragraph 3 is the indication to the Attorney General, obviously without seeking to bind the Attorney General, but the DIFC court marking the seriousness of what has happened. Paragraphs 4, 5 and 6 are orders to require the respondent to undo what she has done. So what we envisage is that we'll provide copies of the trade licenses, and then within 7 days, what she will have to do is submit an application to the Dubai Economic and Tourism Department for approval to transfer 100% of the shares in Black Tap to Sunset Hospitality, and submit an application to transfer 100% of the shares to Brick Oven. And then when that transfer is approved, she's got to attend the notary public and sign the transfer, and we'll attend and sign the transfer as well. And paragraph 7 is an injunction just to prevent her from doing anything with those companies, because at the moment she is in complete control. She's registered herself as the manager, so we can't stop her from incurring onerous contracts that my clients ought not to be saddled with. So paragraph 7 is to make her hold the ring so that nothing happens with these companies until they are transferred back to us. And paragraph 8 is a requirement that she swear an affidavit setting out what she's done. Because as things stand, she's the 100% registered shareholder, although she shouldn't be, and she's also the manager. So she's entitled to enter contracts on behalf of the company, at least prima facie. So we don't know what she's been doing with these companies. She ought to have transferred them to us, but she's taken control, and we just want her to explain what she's done with these companies. And maybe she's done nothing, and we hope that she's done nothing. But if she has done something, then we may have to take some steps to undo that. But I don't know what she's done, and that's why she ought to, at least in writing, explain what she has done. And paragraph 9 simply reminds her of the need to be honest in evidence. Paragraph 10 is quite an important paragraph, Your Excellency, and it's the liberty to apply to purge the contempt. So any party who is in contempt and who has been sentenced always has the opportunity to purge their contempt, which means if they actually comply after the event and do the thing that they should have done in the first place, once they've done it, they can come back to the court and say, I'm sorry, please forgive me, essentially. And if the court agrees that it's appropriate, the court essentially discharges the punishment. And that is what happened in the Gulf Wings case, as I understand it, is that Justice Sir Jeremy Cook imposed a fine, and for some individuals he referred them to the Attorney General of Dubai, and then they ultimately complied, and they served affidavits showing that they had complied after the committal. And His Excellency the Deputy Chief Justice, Justice Ali Al-Madani, saw that they had finally complied and therefore discharged their punishments. So that paragraph is in there to give Miss Al-Herz a final opportunity. She can avoid these punishments if she does the thing that she ought to do. And then paragraph 11 simply deals with costs. Your Excellency's already made a costs order requiring Miss Al-Herz to pay the costs of this application. All I seek is a payment on account. It should be uncontroversial. We can deal with it separately if we need to, but the sum that I would seek, just so that Your Excellency has it, is 103,770 dirham, which is half of the costs of this application. That's including the previous hearings. So the total costs of this application, I seek 50% on account, pending an assessment by the registrar. And then paragraphs 12 and 13 simply deal with service of the order. You will be aware, Your Excellency, that we had trouble serving Ms. Al-Herz previously, and Justice Sir Jeremy Cook made an order You can find it at page 214 of the bundle, allowing us to serve Miss Herz, allowing us to serve her lawyers instead of personally serving Ms. Herz. But since that order was made, she's changed her lawyers. So all we need is a new order to allow her to serve her new lawyers. It should hopefully be pretty uncontroversial. It's just ensuring that the regime that Justice Sir Jeremy Cook put in place continues in relation to the new lawyers. Unless there is anything else that I can assist Your Excellency with, those are my submissions, and I would ask you to make an order in the terms of the draft that I've set out.
Thank you. Hana, you want to say something?
Apologies, Your Honor, Your Excellency, I didn't catch you there.
You want to make any submissions?
Yes, Your Excellency. It will not be long. May I proceed?
Yes, please. Yes, please.
Your Honor, at the commencement of my submission, I would like to seek Your Honor's permission as well to file a short post-hearing submission for the simple reason that we have not had an opportunity to file skeleton arguments since the last witness statement, which is evidence before Your Honor today, was filed yesterday. So it would be convenient for us, or it would be in the interest of justice, if we could please file a short post-hearing submission with some of the laws that I'll be referring to and the cases in my submission, oral submission today. So I'd make that request up front. I would start off by drawing to Your Honor's attention, Your Excellency's attention, the application of the applicants. If I can read that out. The contempt that is being alleged, and I say this because it's very important to the court to realize that a contempt application is a highly technical application, and the allegations must be made very clear. The application notice describes the following as the acts of contempt that were committed by Ms. Herz. She, again, this is from the application notice. It is alleged that she has breached paragraph 1 of the order of this court of Sir Giles and paragraph 2 of the order of Sir Giles. So it's very specific. It's being alleged that my client breached these two paragraphs. In my re-examination of my client, I took my client to those two paragraphs, and as far as the court is aware, she has complied with those two paragraphs by transferring 102 shares, or doing everything she could to transfer 102 shares to the sunset parties. So in terms of the technical allegation that's being made, there isn't a breach of those two paragraphs of the order. Now, I'd like to take Your Honor's attention to CPR Part 81, the English Civil Procedure Rules, which provide guidance on similar sections as the RDC. And if I could read it out, and I would submit this in writing later on if Your Honor permits. It said in section 81.28.4, in committal proceedings, it is important that applicants be clear and consistent about the allegations they are making. And it is important that all involved should be clear about the type of contempt or contempts being alleged. And it goes on to give some case references as well. So this is precisely my point. The allegations of contempt that are made are not contravened by my client, and this application is therefore premature. The right course of action would have been for the sunset parties to either ask for a clarification of the judgment so that paragraphs 1 and 2 could be made more clear, so that our client confirmed that she has every intention to comply with the clear order of this court if she is so ordered. and for that reason, we submit that this application is premature. A contempt order is the most serious of orders that can be issued by Your Excellency or the court, and it should not be taken lightly. As far as the court is aware, the only evidence of our client's intention is that what has been provided by our client. My learned friend asked Your Excellency to draw adverse inferences based on apparent, minor, I would say, inconsistencies in her evidence, but then again, that can be explained by the fact that English is not her first language, and she had difficulty in expressing herself. However, in my submission, I would say that as far as today's hearing is concerned, there is no evidence of intentional wrongdoing by our client. All our client did was take part in the process of complying with the judgment. She has done what had to be done on the advice of Dubai court officials, Dubai government officials. It cannot be suggested that she has done something untoward or something that is improper. And certainly it has not been directly alleged by the Sunset parties, so that allegation is not there. If such an allegation was made, my learned friend's clients had every opportunity to file criminal complaints and investigate this matter. Instead, they're asking Your Honor to do that investigation without even appropriate evidence. And that's certainly not the proper course to follow when serious allegations of this nature are being made. My client confirmed that she does not have the power to transfer shares in a manner she wishes, and that she acted at all times on the advice or the directions given to her by the relevant departments. My learned friend also submitted that my client has effectively breached the prohibition contained in the order of Sir Giles. That's not the case. A prohibition in the manner that my learned friend suggested assumes that a person has done something to contravene a judgment in a manner that it cannot be reversed. My client has not done that. She has only, once again, complied with part of the process. It's always open to her and my learned friend's clients to resolve the matter and to comply with any transfer as the court would order. So the prohibition test that my learned friend advocated is not applicable in this situation because, okay, the judgment has not been, if there is a judgment, it has not been frustrated. I would also state for the record that the matters in relation to the technical manner in which the share transfer took place, the articles of the memorandum, all of the interpretation of all of that is strictly under the jurisdiction of the Dubai courts. Not that it matters because, again, our client has not contravened any order of the court, but for the purpose of the record, my learned friend's submissions about the manner in which this took place is again not something that the DIFC courts can really look into, even if it's relevant to my client's conduct. In terms of the orders sought, I would again submit that the referral to the Attorney General, if a reference is made, would be an instance where Your Honor is effectively telling the Attorney General that there has been contempt because my client has followed the advice of the officials of relevant departments. And in my submission, that would be highly unfair, especially when my client confirmed that she has every intention to comply with any order of this court, and there is prima facie evidence of her compliance, of her attempts to comply with the order at least. My client confirmed that as far as she was aware, she had the renewal of the trade license was done again for the benefit of the companies and not for any ulterior reason. So again, intention has not been established to the level required to establish contempt of this court's orders. In terms of cost, our submission is that there's certainly disproportionate cost being incurred in handling this application. So if Your Honor is inclined to order that the issue of cost be determined, or if not agreed, be determined by the registrar, that would be an appropriate way to go about it. I would also finally submit that, once again, request that we be given an opportunity to file a short post-hearing submission so that we could put in the laws that we referred to in more detail to assist Your Honor. If there's nothing else, I would like to complete my submission.
Your Excellency, may I just make a couple of points very, very briefly in reply?
Very briefly.
Your Excellency, it was said that the allegations that I'm making were not contained in the application notice. If Your Excellency goes to page 3 of the bundle, that's part of the application notice. You can see that it's the application notice that was issued, and about a third of the way down the page you can see the little number 13 and the sentence with reference to RDC 52.92. The grounds upon which this committal application is made against Ms. Al-Herz are as follows. 1. Ms. Al-Herz has failed to comply with the transfer orders by 10th of June 2022 or at all. Ms. Al-Herz has deliberately disobeyed the transfer orders. 3. She's deliberately sought to frustrate the transfer orders. 4. On the 25th of July 2022, Ms. Al-Herz secretly and deceitfully registered 100% of the shares in Black Tap in her own name. She also purported to appoint herself as managing director by amending the memorandum, etc. And then little 5, in addition, on 9th of August 2022, Ms. Al-Herz secretly and deceitfully transferred 100% of the shares in Brick Oven into her own name. She also purported to appoint herself as managing director, etc. The Sunset Parties first became aware of the subterfuge on 29th of August 2022. So it absolutely was the case that everything that I put to her and everything that I submitted was included in the application at the start. And there is nothing in my learned friend's submission that somehow the nature of the allegation is changing. All that's happened is it's not being met. It was said that you can't, that the test, the prohibition test, as my learned friend put it, can't be met because it could just be enforced. Sorry, Ms. Al-Herz is able to reverse what she's done. Well, that doesn't matter. The fact that you can be ordered to undo the acts that frustrate the order doesn't mean that you haven't frustrated the order. If you frustrate the order, you do something that is not only not compliance, but means that you're putting yourself in a position where if you are to do the thing that you're being asked to do, it doesn't constitute compliance. Absolutely, this court can order Ms. Al-Herz to reverse what she's done. And indeed, it was sort of suggested by my learned friend and suggested by her that if only this court makes a very clear order, that she'll comply with it. I mean, it sounds like she's trying to negotiate with this court and that her position is, well, I'm only going to comply only if this court makes the right sort of order. That's precisely the sort of conduct one would expect from someone in contempt. Fourthly, it was said that this court doesn't have jurisdiction because there are matters to do with the memoranda of companies in the DIF in Dubai. That's not correct. This court has jurisdiction to deal with contempts of its order. You can't evade contempt or a committal application by saying, oh, well, my actions relate to something in Dubai, because all your Excellency is considering is whether Ms. Al-Herz has complied with the order or deliberately frustrated it. And finally, it was said that, well, it would be very unfair to commit her for simply following the advice of departments in the DED. Well, I don't accept that they gave that advice, and there's no evidence other than Ms. Al-Herz's assertion in evidence, somebody who Justice Giles has already found concocted evidence. So there's no independent evidence that that's what the DED advised. But even if it did, As I said to Your Excellency, a party who was honestly seeking to comply would not have executed those deeds immediately. They would have got in touch with my clients and would have resolved the situation, but she didn't. She transferred all the shares to herself and then has set about trying to negotiate with my client and this court. It's quite clear that she just doesn't want to comply and wants to hold on to as many shares as she can for as long as she can. And that, in my submission, is why she is in contempt.
Okay, thank you.
Sorry, I'm just being told by my solicitors, I should have mentioned this. There is a typo in my order, just so that Your Excellency has it. At page 833 of the bundle.
Okay.
Paragraph 4 refers to the trade licenses for black tap and brick oven. I'm told that actually that should be Sunset and Patura, because I think that's what Miss Herz wanted. Was we don't say she needs them, but she wants the trade licenses for Sunset and Patura. So I think in paragraph 4, black tap just needs to change to Sunset and brick oven to Patura. But apart from that, it's all fine.
Okay. If no one wants to add anything, we will conclude this hearing.
Thank you, Hana. Are we permitted to file further submissions, or is that sufficient?
No, your submissions for today's hearings are sufficient. I don't need further documents from the parties.
Okay, thank you.
I'm grateful
Thank you both for your time. Thank you.
Thank you very much.